Okay, so so are mentally ill people allowed to have sex? All right, but you can consent to sex, but deserve special consideration. The individual must have knowledge, rationality, and voluntariness with respect to the decision to engage in specific sexual activity. Right. Here's an article from the Washington Post, right? Now, since we're discussing words and topics, okay. All right, this is by Eugene Volokh, and he contributes to the Volokh conspiracy. So, the criminal law of rape and sexual assault is a tort, right? And the civil, and could be battery, right? Now, autonomy means that's your right not to engage in sex. But it also protects the rights for someone to engage in sex constitutionally. Why? Because sometimes sex can make you feel good, or sometimes it can make you feel bad, right? And that also depends on how the person treats you after the sex, right? Right. The classical dividing line, of course, is consent, whether expressed or implied. In other words, if I'm making out with you, right? And you don't say stop or no, you're consenting to what? Sex. If I'm pulling down your panties and your shorts and you don't say no or stop me, right? And another thing is you can't have sex with someone that's unconscious either, who cannot consent. But what if the person is asleep and maybe tried to do a little something with you earlier but stopped, but then you woke up and did something yourself, right? And the person seemed to be responding sexually, but you weren't sure if they were asleep or not, right? All right, so people who are mentally ill, though, can they legally consent, right? That's part of what the article's about. And a familiar example is children under the age of consent who cannot legally consent to sex. Even though are factually enthusiastic about having sex, all right? Though Romeo and Juliet, which has to do with children who are close in age, right? Even if it's a crime for an adult to have sex with one of the children, right? Is it that a 15-year-old lacks the capacity to consent to sex with a 25-year-old, but has the capacity to consent to sex with another 15-year-old? Or is it something else, right? See, this is a controversial topic, right? And there's also the age of accountability. If the child also knows it's illegal to have sex with an older adult, can they pursue the older adult and give them a false age, like in Fast Times at Ridgemont High, where the girl said she was 18 but was really 16 or 15, right? Did the man knowingly have sex with an underage girl? No, he didn't. He didn't. So, but that's why I say you card. If someone shows up in the middle of the night, you card them and make sure they're old enough to be with you. So, another case would be the mentally ill, or mentally disabled, right? Like me and even Michelle. Because Michelle was considered emotionally a 5-year-old child, right? But she had also had sex with someone else who was of age, right? And I was not her first sexual encounter, right? Because, like all people who are aging, right? Even though the courts might have determined she has the mental capacity of a 5-year-old child, she knows in her body she's an adult and obviously had sex with a few men, or at least two, right? Another guy and me, but I wasn't the one to pop her cherry or anything, right? Right. Which is important too, but I'm also dealing with paranoid schizophrenia, right? All right. If you say it's a crime, though, to have sex with a mentally or disabled because they lack the legal capacity to consent, that consigns them to a sexless and often, therefore, emotionally diminished life, right? See, you might say, well, marriage ain't about sex, but yeah, it is. Yeah, it is. See, part of marriage is sex. It's not the only part, right? But it's at least 30 to 50% of a relationship, right? And it also limits their pool of prospective sexual partners to those who are willing to commit serious felonies, right? On the other hand, if it's legal to have sex with them, which opens the door for them to be sexually exploited, right? In ways that are hard to explain as, hey, that might seem degrading to us, but that's their choice. I know. Given that their mental limitations make it much harder for them to make an intelligent, right, reasoned decision, right? In any event, the Connecticut Supreme Court decision in Kortner versus Martiz offers an interesting illustration of this. Caroline Kendall Kortner, labeled Kendall in the opinion, was apparently bright and articulate. Indeed, she had gone to the University of North Carolina, so her intellectual capacity as such wasn't an issue, but she was apparently seriously mentally ill. She had been diagnosed with clinical depression, borderline personality disorder, obsessive compulsive disorder, anorexia nervosa, bulimia, nervosa, and periodic dystonia and catatonia, right? And her mother had therefore been appointed her conservator, right? Kendall got involved in a romantic and then a sexual relationship with Craig Martis, who apparently involved a good deal on sadomasochist behavior. After the relationship was over, Kendall's mother, as Kendall's conservator, sued Martis on her behalf, claiming partly that Martis had, in fact, had sex with Kendall on some occasions without Kendall's consent, and partly that Kortner was simply unable to consent, right? Which is the mother doing it, right? You see what I mean there, too? Right. Now, another point for me to point out is I'm legally able to take care of my own finances and make certain decisions legally. Like I can buy a car, right? Or a house, or a house. Right. The opinions are complicated, and I have run and can't do them justice, but anyone who is interested in the sexual autonomy rights of the mentally ill ought to have a look at them, especially the majority in principle partial dissent. Now, but who's more upset than the girl who went into a sexual, almost sadomasochist behavior with the man, right? Or the mother, right? Who's in charge of the girl's finances, or whatever you want to call it, right? Much of the discussion has to do with evidentiary error questions. The jury ruled for Martiz, but the majority reverses and remands for retrial, largely because it concludes that a certain document was improperly omitted and the court failed to alert the judge to the jury's question about the document. Still, in the process of resolving the question and dealing with some others, the court talks about the facts of the case and implicitly demonstrates why capacity to consent is such a thorny issue in these situations, right? Because, see, legally, the girl's also, what, old enough to consent if she's college age, right? Now, like I said, if you ask a girl in a salon and she's 16 years old and can't work in one till she's 16, that's different than a girl working in a, say, a restaurant or a theater where she's can be 14, right? But either way, the girl cannot lie to a customer, have sex with the customer normally either, not even in the bathroom, which is the only place you can do it in the store. Just saying hypothetically that. Don't forget that either. But one holding by the court, though, is pretty straightforward, though important. The mere fact that a person is sufficiently impaired that she requires some sort of conservatorship doesn't make her legally incapable of consenting to sex. One paragraph break added, right? The crux of the plaintiff's claim is that it was important for the trial court to allow the defendant to present evidence that Kendall consented to the sexual contact between her and the defendant on the grounds that Kendall was legally unable to consent because she was a conserved person. A conservator only has the authority specifically assigned to him or her, and any one decision-making authority remains in the conserved person on the bias of the statutory scheme for conservatorships. We cannot conclude that any conserved person is legally unable to consent to sexual contact. Instead, we conclude that the issue of whether a conserved person is able to consent to sexual conduct is a factual question for the jury to decide based on the nature of the particular conservatorship and the ability of the conserved person. In other words, she's not going to ask her mother, can I have sex with this guy if she's in a relationship with him, right? Right. Basically. In the present case, the plaintiff did not establish or even allege that her appointment as conservator of Kendall's person specifically included the duty of managing Kendall's interpersonal and or romantic relationships. Indeed, at the trial court, as the trial court recognized, the evidence demonstrated that Kendall lived in her own apartment, right? Spent unsupervised time there and was able to make decisions about her household chores and carry on interpersonal relationships, including those on the computer, right? In other words, she talked to her friends and family email, right? Instead, the plaintiff maintains that the fact that Kendall was a conserved person was sufficient by itself to demonstrate that she was unable to consent to sexual conduct. We disagree. A bright line rule on this issue, as suggested by the plaintiff, would be contrary to clear legislative intent as exemplified by the statutory scheme. It would further affect the civil liberties of all conserved persons. Therefore, we conclude that the final determination of whether Kendall had the ability to consent to sexual contact is a factual question that the jury must decide, right? Surely that much at least is correct, right? In our decision to protect the mentally ill against potential coercion and exploitation, we should consign all conservatives to sexless lives of a sort that most of us wouldn't wish on ourselves, right? Should we, though, leave the question of consent to the conservator, right? Who could therefore authorize a third party to have sex with the conservatee, right? It's like when a 16-year-old wants to marry an older man, right? She has to do what? Get her parents' permission, right? And they can give the permission, right? Or deny it, right? If the conservator thinks this is the conservatee's best interest, is that a sensible solution for the mentally ill or mentally disabled? Mm-hmm. Even if this sort of I need my mother's permission to have sex, exactly what they're saying, the position is very much at odds with our views of sex, right? Whether involving competent adults or even children. Also, if the conservator can give consent or the conservatee's behalf. Now, if at all, if at all, should the vicarious consent be reviewed by the government? For instance, if the government thinks the conservator is essentially pimping out the conservatee in exchange for money or favors, like with stories you might see on SVU, right? Sometimes the mother will pimp out the daughter for sex to get a hit of crack. Yeah. For a related question, how may the government act when criminalizing an otherwise consensual sex act on the grounds that the sex partner is too mentally retarded to consent to sexual contact, right? See Anderson versus Morrow, Ninth Circuit, 2004. And the debate between the majority and Judge Berezin's dissent. Also, see this post and this one. Right, there's two more posts. Sorry. Mm-hmm. Now, I'm basically reading you the whole story, right? So I'm quoting him as well. Mm-hmm. When you do that, right? And you say I'm quoting Eugene Volokh, however you say it. Volokh. I think that's how you say it. Hope it's close enough, Eugene, there. But since this is an article concerning me, right, and I'm mentally ill, what I'm asking is, can I consent to sex with a woman of age, right? And again, or is the woman, even if she's underage, and knows she's 15 and tells me she's 37, taking advantage of me? Because I might believe her if she tells me she's 37 and have sex with her even in the bathroom, which is, again, the only place you can do it in the store. And I have had an occasion where I had sex with another woman in the store, and I said that too, right? Though it was in kind of the break room area, and no one was there, of course, after the store closed around 11 p.m. So again, can someone, but that was before I was diagnosed with mental illness. Yeah. Exactly. But I don't know what exactly happened in the salon, but I do know I lost about an hour of time because I was going to see a movie. I know. Now, what do you think, like I asked you before, if you're trying to find a girlfriend, and the girl don't you see what's under and you felt like the people in the salon might have been picking on her about you being a big man. And again, having to touch your feet a little bit up to the calf while doing your nails. What do you think they would be talking to her about? Which you would have to explain to her is not the case, but you don't want her to worry about it. But if they keep embarrassing her, you want her to know, hey, look, that don't even excite me with them. I've had contact, up to the leg, and I don't always respond, right? Up to the knee at least, right? And I usually can behave myself like when I'm dancing fast with a woman, right? That's different than slow dancing with a woman. I don't usually have a hard on when I'm dancing fast with a woman. But when you get real close and you get real slow, you're making it hard for me. To quote the lyrics. That's all. Right. I don't know the name. But it's a song I heard on the radio at the club scene. Right. See? Maybe you've heard it too. I don't know. I don't know. Again. But like I said, no one, if you're trying to explain something to them and telling them no, and you're not supposed to do it with me, it's supposed to force it, though, or push it. Because, see, that's still not consent on the other person's part. He's telling you, we can do it, but we are not supposed to do it because Abraham and Sarah did it, right, for example. But, again, I'm not saying, I'm condemning the person either. What I'm trying to establish is I don't even know the person did it. That's where the crime comes in at, because someone did what? Caused you amnesia. Right. Whoever caused me the amnesia there, I don't know. I was with the person as well. That's kind of the real problem. Because to cause someone amnesia means you had to hit him over the head or something. Or shoot him in the eye or something with the gun. And that's attempted murder, which is upping the ante against the girl, if I'm mentally ill or not, and she is a part of that, right? Herself, right? See, that goes to, again, accountability if the person also committed the crime of assault and battery, which for a mentally ill person can be a felony. If you assault me for being mentally disabled, and I'm telling you on YouTube I'm mentally disabled, right? You can't do that either. Now, legally, though, who determines if I can have sex with a girl? Me.